Good evening and a warm welcome to this Vidhi Talks workshop organized by Bar Council of Punjab and Haryana, Chandigarh. I am Advocate Khyati Oberoi and I'll be moderating today's discussion. We'll discuss the draft data protection and data privacy rules which have now been made available for public awareness. In an increasingly digital world where data has become one of the most valuable assets, the need for robust data protection frameworks has never been more urgent. Earlier this month, the government proposed a new set of rules aimed at regulating how personal and sensitive data is collected, processed, and stored. Some believe these rules could be helpful, strengthening safeguards for individuals and aligning our regulatory frameworks with global standards like the GDPR. However, other questions their feasibility, impact on businesses, and whether they balance protecting privacy and enabling innovation. We'll begin the discussion immediately. I'll introduce each panelist and then ask questions. After one answer, if anyone wants to fill in, they can before we move on to the next question. So let me introduce our first panelist. We have Shashank Pandey, an accomplished lawyer currently working as a senior consultant in data privacy practice at Ernst& Young. He has also worked with KPMG and Legacies and briefly ran his own litigation practice. He received the Nani Palkhiwala Gold Medal during his LLM and holds his BBA LLB and LLM in law, policy, and good governance. The second panelist is our Shailendra Pathak, an experienced lawyer with 18 plus experience in trial courts. During his career, he has handled diverse matters including IPR cases under the IT Act, arbitrations, and corporate law. And he holds a Bachelor's of Social Legal Science and an LLM in Business Laws from Pune University. Moving on to our third panelist, we also have joined by Sandeep Arya, who is a managing partner in Masters and Chambers and also a distinguished lawyer with over 20 years of experience in the legal field. Faculty of Law, University of Delhi graduate, he is an active litigator in the fields of IPR, privacy and data protection, company and cyber law, media and telecommunications, ISP licensing, and broadcasting laws. Welcome all to this interactive session.
Thank you, Khyati. Thanks a lot.
Thanks a lot, Khyati.
You're welcome, sir. So let's begin with Shashank, sir. The proposed data protection rules introduce several new provisions. From your perspective, what are the most significant differentiators in these rules compared to existing global frameworks like GDPR?
Okay, so before we deep dive into that question, the first and foremost that all of us should know is there are like 5 or 6 basic principles of data privacy which is followed across all the regulations that you'll find in the world. Now, predominantly, DPDPA also follows the same principles, clearly calls out the requirements. Same goes with the rules. Now, where we have gone a bit differently, or wherein we say we can see an impact of DPDPA rules is one in the obligation side of data fiduciary, otherwise known as data controller under GDPR and other laws. Then we have seen for the first time that a data subject, otherwise in Indian context known as data principal, has to be, and probably the first time in Indian legislative regime that I have personally seen that duties on a data principal has been imposed with a hefty fine as well. So these are two things which are majorly distinct from baseline documents such as GDPR or any other ISO certification or standards. Then cross-border data transfer, unlike GDPR, you would have seen we have a whitelisting of countries being done here. And that is something that businesses have to be slightly worryful about, because as we know, whether it is an Indian MNC or an SME that works across the globe, we have to understand that where our data is being stored is usually in a lot of countries in a cloud environment, and not a lot of us end up knowing where it is actually being stored in terms of geolocation. So we have to follow those principles. So these are some pointers. I mean, from an overall rules standpoint, again, in my personal opinion, again, I'm not endorsing my organization at any point of time, but considering how DPDPA came into being, it was very simple, very simply drafted in a plain language. Howsoever, in my personal opinion, it is vague. And that was also somewhat followed by the rules as well, because when you talk about implementation timelines, there's none. Then when you see the divergence in, let's say, there's a 70 or a 90-day timeline, let's say, in an extended period of environment that a GDPR will give. Now, in India, to address the grievances, it is on data fiduciary to decide by when they'll have to get back to their data principles. Another thing is the role of consent managers. That is for the first time in Indian context that we are looking at. I mean, across privacy regime, there is never before done, and how it is going to be implemented is still, a moot point, because again, they have given a lot of criterias for what a consent manager will be or what are the qualifications, but how they are going to function from a tech enablement perspective is something to be seen. Verifiable guidance, another point. So I mean, the basic principles aside, how we are going to implement all of this is something which is going to be challenging, and this is something very divergent from all the existing frameworks. So yeah, those are my two.
Thank you for highlighting those key points. Now we shall move on to Shailendra sir. Sir, in terms of data principal rights, how do you see the proposed rules aligning with the GDPR's emphasis on the data subject rights, such as the rights to access, correct, and delete personal data?
That's very interesting. Also, recently, in the light of what Shashank has just put forth, this passing of this act is our baby steps towards a more robust data privacy for the data subject. Now, if we see, we are a country of 1.4 billion. Most of the people are struggling for their basic rights. Like right to life and liberty is being compromised at every nook and corner. There are things about civic rights. There are things about infrastructure and stuff. So it's a very bold step. DPDP is a bold step towards enhancing the general rights. Yes, it is a very welcome step, wherein people will start being sensitive about their rights as a data subject. But as rightly put forth by Shashank, I would agree with him 100% that the implementation is going to be a challenge. For a country so big, which is out of which, out of 1.4 billion, if we imagine, there are at least 80% people who are on social media, who are connected to data, who are exchanging data in one form or the other, sometimes sensitive, sometimes insensitive. So regulating all of this with one act may not be, I mean, if it happens, it's going to be just a miracle. So we will need more robust infrastructure in terms of data protection, data privacy. We need to educate our executive, the police machinery, which is in charge of protecting the rights, personal rights of the citizens. And we also need to educate the judges, the lawyers, who need to understand, firstly, the need for data privacy, and then for the rights of the people. So I think it's a very welcome step. And of course, we are anxious as to how it will pan out in India. But yes, I welcome DPDP in all its forms. And
that's an interesting comparison, sir. Sir, there is one major difference between the GDPR and the Data Protection and Data Privacy Act. Would be the role of the government agencies in data governance. How does the DPDP's enforcement mechanism compare to GDPR's independent regulatory bodies?
yeah, so as I said, we have brought in the act. We need to have machineries. We need to have enforcement machineries, which is lacking in DPDP. They have formulated an act. They have given the rules. They have said this is what is going to happen. But if you say, let's say there is an infringement of data privacy, a person whose data is infringed will run to the police station. Yeah. maybe he's then directed to the cyber police. The person sitting there in the desk, he has least sensitivity towards your data rights. He is trained in a fashion where he says, अरे हम यहाँ पे मेरे हाथ में मर्डर का केस है सर, आप कहाँ ये डेटा का लेके आए हो, चलो कॉम्प्रोमाइज हो गया, बैंक में फोन करो और ब्लॉक करवा लो कार्ड, कल देखते हैं. So we will need an implementation which is equipped, sensitized first, then equipped to handle such situations and understand the seriousness of data compromise. For example, if the data subject comes and says that my personal phone has been hacked and all my data has been compromised, it may have a lot of compromising things for the data subject. It could have intimate pictures, it could have phone numbers, it could have passwords to the banks. And it is important that the law puts in a machinery which can stop it right there and then, which we are lacking. I mean, you can't expect a person to run to the court and file a writ in the high court saying that, sir, मेरा data compromise हो गया, government machinery काम नहीं कर रही. उतने में उसके सारे बैंक अकाउंट खाली हो जाएंगे, उतने में उसका जो पूरा डेटा है वो लीक हो जाएगा, कम से कम 10 ब्लैकमेलर्स की कॉल आ जाएंगे कि मेरे पास तुम्हारा ये डेटा है भाई, इतनी फिरौती जमा करो. So having it on paper and having it in fact, there's a vast gap. I think the government should start working on bridging the gap as soon as possible. Like yesterday. It should have started yesterday.
That's a great perspective, sir. Now I should move on to the next panelist, Sandeep, sir. The Data Protection Board of India has been established under the Data Protection and Data Privacy Act 2023. What role did you see that the board has played in ensuring compliance with the provisions of this act, and how crucial it is in protecting individuals' data rights?
So, thank you, Khyati, and I again welcome all the panelists here. And this is an opportunity offered to me. I'll just try to explain whatever my understanding of this law is. So, if you see the mechanism provided under this act, let's talk about Section 18 first. Section 18 gives power to the central government to establish a board, which has not been done yet. Central government will establish a board which will be called a Data Protection Board. So board in a parallel has been given certain powers under establishment is under Section 18, and then powers have been given from Section 27 onwards of the law. So there would be a constitution of a board, and board if I'll break it into 3-4 aspects. So one is on the intimation of the data breach, which has been, what is data breach has already been defined under the act. Under Section 2U, the data breach has been defined. If I'll go to that, I'll take lot of time, but I'll just, for your viewers' benefit, I'm mentioning the section. They can go and read what is data breach. So on the intimation, that board can initiate, give a direction to the data fiduciary or the consent manager, whosoever is involved, to take a mitigating steps, that whatever the ill effect it may have, the breach, you just, mitigate them so that it could be minimized. The threat and risk, that one example was mentioned by the Shalinder in his address, that there could be leakage of data or breach of data, and it could, we are living in a, social media times. So it can, go like a wildfire, faster than wildfire. So mitigating step, then Section 27 itself gives power to the board to inquire. Then this one is mitigating, then inquire into the affairs, how it has happened, who has happened. Then it has also power to impose penalty under Section 27. The board under Section 27 has been given powers to impose penalties. And then there is a procedure prescribed in detail how the inquiry has to be done. What are the principles of laws to mention, say, hearing opportunity should be given, a person should be heard, then only inquiry, and there could be collection of evidence, taking evidence on oath, if somebody is required, So making their presence, to be presented before the board. So there is detailed procedure prescribed. Yes, but having said all in detail, board has been given enough powers to take care of the implementation and do justice at the at being. I'll say it would be a court of first instance under this law. In addition to that, I'll just say the board has also been given a power to pass an interim orders. So when there is a board comes to a conclusion that this some breach has happened and this is some damage, so board has been given power to pass interim orders as well.
That's a great explanation, sir. Sir, there is one more section 28 of the Act, which grants that the board significant powers in inquiries, in the authority to summon person, examine witness, all of the civil court powers. How effective will these powers be in holding data fiduciaries accountable for violations of data protections?
So let's just break just to understand for a better understanding of your viewers and listeners or audience. Let's break it into 3 steps. One, we understand who is a data principal in our parlance of law. A data principal is an individual who the data belongs to, any data. Then there is a concept of consent manager is there. Then there is a data fiduciary and data processor. So if I'll put it by example, data fiduciary is a person who will decide the purpose and use of data. So for example, say if I am a banker, I'm running a bank and you being a customer. So I own your data as a data fiduciary, it belongs to you. But to do the processing, I take services of other company who processes the data, maintains the data. So I become a data fiduciary and that person who is processing, it becomes a data processor. So it has to be ascertained before you take any action that breach has happened at whose end. Then say a relationship between a data fiduciary and then data processor could also be governed by the contract. Suppose if I outsource my services to somebody else who's, it could be case that I am fiduciary at the same time I am also processing in-house only. So the all liability will be on me. But if I am outsourcing it for processing, so there could be that could be a contract between the parties. So that contract will also has to be looked into. So coming back to your question, so I'll just quickly say that board has been given power of a civil court to take evidence on oath, to call for records, maybe digital or non-digital, to ask somebody and summon somebody to be there. In addition to that, board has been given power to take the services and help of a police authorities. So all these powers has been done with some intent that this board has enough powers. It should not become a paper tiger only mere. So it could do the mandate which has been given under to the board law justice to it. So it should not go to other forum and to seek help. So it has enough powers to deal with the matters which has come to the board.
Thank you for such insightful thoughts. Vedar, sir, you.
There is an interesting perspective to what Sandeep sir has just said. There have been instances in the past where great enterprises have been started, but the purpose has been lost. Like for example, RTI is one of the most effective bills passed. Jan Lokpal and RTI, when it came into force, they started with best intentions. If it is not regulated properly, what happens is it becomes a tool for blackmail. RTI, we have seen many cases that RTI has become a tool for nefarious activities. It has been used to hold politicians accountable. It has done a lot of damage. So so I agree completely with Arya sir ki if it is not regulated properly, it is a huge tool for mass destruction. It could be used against people, against civilians, citizens of this country. So that also has to be taken care of. I mean, I 100% agree with Sandeep sir on this.
Also, just to add on to what Sandeep sir had just said, in the draft rules, if you'd go through, there's no processor obligation as such in comparison to what GDPR will say. So now what happens is, and again, me being a data principal, my primary contract lies with my data fiduciary, and the obligations are mostly on data fiduciary, even in other ways. So even if you see in any other GDPR, CCPA, CPRA, and compare it with the DPDPA rules or the act, you will see there are certain processor obligations. Now, in cases of breach, in India specifically, I mean, as the case stands today, even though there will be contractual safeguards protecting data fiduciary from data processor damage, they can it's between them. It's data principal will always end up claiming it against data fiduciary, and I mean, there has to be a bare minimum baseline requirements that draft rules are dictating right now. Earlier, SPDI also used to dictate that. There was a BIS standard also, which was made basis 27001 and 27701 ISO standards about the security safeguard. So there, I think, is something which is being done, and the primary claims will lie against fiduciaries. Between fiduciaries and processors is a separate thing altogether. Second, coming on to the point wherein the investigation and notification things were discussed, it is fiduciary's responsibility to immediately notify all the data principles about what has happened, what is being done to mitigate it, and what are the principles. So usually when we draft those notifications, we usually put there is a column says what you can do at your level. And mostly it is about change your passwords or take your download of your data, don't respond to OTP requests and everything like that. And to adding on to what Shailendra sir said, like about awareness point of view, again, considering the point that Justice Puttaswamy case gives it out as a fundamental right, now we also need to understand that out of 1.4 billion people, there are a lot of digitally illiterate people in this country.
Yeah, and they're there.
Right?
They're operating right, left, and center.
Yeah, so for them, I think there are a few awareness campaigns going on from the government and might come out with another set of campaigns, digital campaigns or offline campaigns. And another thing that was kind of, bit problematic that I saw in all of this was, unlike in any other jurisdiction, this is the only digital data that we are talking about in India. Considering the nature of paperwork that is flying around specifically in Indian offices. I mean, most of you might be traveling, they might take copy of your passports, Aadhaar, left, right, center, where they're storing, no one knows who's taking it. So because in India, where we see the crimes like, impersonation happening,
identity theft, yes,
frauds happening, it is basics, because I have a first-hand account of my own friend whose PAN card was issued to another person as well at the same time. I don't know how, but now that guy is in lakhs of debt, which he hasn't taken. So considering all of that, I think there has to be something like, I mean, these guys are coming out with the Digital India Act as well, might be replacing IT Act soon. They have come out with AI guidelines as well, considering deepfakes and all of those things. They are flying around left, right, center on social media. So there are things which are being done from the government's end, and justifiably so, considering the lines used by JPC in their report, data is the new oil. And oil is definitely a commodity of national importance. So government has decided to keep themselves out of all of this setup that they are creating for private entities as of now. Yeah. Over to you, Kathy.
That was a great quote, sir. Sir, I have reading recently about the data audits also. That will ensure compliance and how companies identify vulnerabilities before they even become a serious threat. So the rules propose that data audits access security protect personal data. How important do you think these audits are in proactive identifying risks?
Okay, so I guess for the people in my domain, it's our bread and butter. Data audits, security audits, and it's not for the first time. I think any law is mandating such audit. And RBI, SEBI, IRDAI, all of these guys already have those audits in place. So in one way or another, these companies were doing it. Also, there's an internal audit function which is across all the big MNCs. Now, what we see in DPDPA, that audit is only mandated for significant data fiduciary. Another pain point is who's going to be significant data fiduciary, which rules don't clarify at all again. Now, it's so when we talk about adoption of these laws, right? The first step is always we do a current state audit where you stand today. What do you all need to do? So when we do a current state study in any of these organizations, we highlight all of these gaps and tell them what are the non-compliances, what should be implemented to be at par with what industry standard is or what law is suggesting. And if the companies take that thing seriously, so now there is a risk appetite also. Might differ from company to company and out to out. Now, once if there's a risk, let's say an outright risk which says now in your website you do not host a privacy notice, and let's say our act says that in scheduled languages also the notice has to be given. Now the interpretation of this has to be done in the circumstance of that particular company who's the target audience. Now if I am let's say a Tamil newspaper, my readership knows Tamil. I'll only give it in Tamil and that justifies the compliance. Versus a bank wherein they are present across the country, they'll have to maintain all of those things. So the audits will give you findings like this, and then you'll have to, and now ESG reporting, within the ESG reporting, there is a section of data privacy which you have to put out, like how your privacy program is functioning, and that is an important criteria in that reporting. And after taking that, after creating those remediation steps, how proactive those companies are, because so far what we have seen in India is a reactive approach. Now we all have to do is a proactive approach towards privacy. Now the companies which were there, who were already abiding by GDPR and laws like that, they are, at least what I would think of is 60 to 70% they are there. And now what they have to do is the other 30-40% data that is currently in place with respect to the DPDP itself, and they'll be in line with the laws. And I hope the government will give that kind of time to create those controls and put them in place for all the companies. So yeah, audits are a major part of the compliance, and it gives you kind of it builds a trust also, because if the companies know, if they have brought out the changes, they will inform their data principals, okay, we are implementing this, and more often than not, we don't care about it. How many times, if any one of you have gone through your Android updates or an Apple OS update, wherein you go through and see what they have actually updated, which means it was not there. Any security update, why it comes? Because there's growing threats, there are vulnerabilities present within those digital ecosystems, and therefore that update comes out. So if the companies are proactive, they take their audit seriously, they take their testing seriously, they'll put out those updates and implement them timely, they'll be secure from whatever threat is coming their way. Over to you, Khyati.
Yeah, sir. When we are talking about the data audits, we also talk about the data protection officers. So I would like to ask Shailendra sir regarding this, that the role of data protection officers includes monitoring and auditing data processing activities. As organizations embrace new technologies such as AI and machine learning, what role should the DPO play in ensuring that these technologies are used in compliance with the data protection provisions?
So It's actually a very relevant question in terms of the role of the data protection officer under DPDPA. So under the GDPR, the data protection officer has certain roles and is answerable to the government machineries, right? Whereas under DPDPA, the data protection officer essentially is a private person. He is most probably employed with the data fiduciary, or he is being at least paid as a consultant by the data fiduciary. So what happens is sometimes it is very important for the data protection officer to safeguard his life and rights when he gets complacent with a data fiduciary that is involved in some unsavory work, as I may put it. Sometimes, for example, let's say there was a case in the European Union against Facebook for uh, use of data beyond the permissions, so they have so I'll try to reduce the jargon out of it. So what they did was they had permissions to use the data for certain purposes, and they have used and sold the data to data players for other purposes, and because of that, a lot of people lost uh, a lot of data. It is also said that one of the US elections was rigged, and this data was used, data was compromised, and it helped in swaying the election results in favor of one of the parties. This is a serious issue. So when the data protection officer, whoever is acting as a data protection officer for a data fiduciary, it is important for the data protection officer to keep sensitizing and training the employees and the top management about data breaches that are happening voluntarily or involuntarily. First, because he is in charge of the data security, of data privacy of the subjects, data subjects. So he or she cannot be blinded by the amount of salary that is being credited in the. So whenever he finds that there is a possibility of data being either leaked or compromised or being used by the organization, which would lead the organization in trouble, which he is a part of, he has to be sensitive, he has to raise flags, and he has to, if needed, he has to drive the change of policies of data use. He has to help them formulate the data policies compliant with the requirements of DPDPA. He has to conduct trainings for the employees handling the sensitive data, sensitive, non-sensitive, incidental, whichever data, metadata, for example. So there has to be a continuous training that should go on in the mind, firstly, of the data protection officer, and then he should implement it with the top management and with the employees, the foot soldiers who are operating and working, handling this data for the people. So that requires a lot of moral strength when you raise a red flag against the organization which is paying you. But then the data protection officer has to convince the organization that it is for your benefit and for the benefit of all the people working with you that you change this policy and you do not use this data in such a fashion. So data protection officer's role is critical. It is very critical, because ultimately he could also be held responsible if a criminal prosecution is launched against the company. He has been a part of the company. He is. So he's shouldering that responsibility of protecting the data as the first henchman of the company. So I think the role is pretty critical. And all the people, all the youngsters who are thinking that they will become data protection officers for the lucrative money that is being offered, understand it's like Spider-Man. With great power comes great responsibility. So that's what I would say about it.
That was very helpful, sir, especially regarding the role of the officers. I would like to ask everyone who were here that what are the challenges we see for the implementation of with the rise of technologies like AI? What challenges we see for the implementation of these rules when we have the technologies like AI, fintech, and everything around? Anybody?
So I'll
Sorry.
try. Okay,
Sandeep,
Surendra, please go
please
on.
go ahead.
I'll supplement you.
I particularly feel that India as a country is not prepared for AI. We have brought home a king's daughter, and we cannot bear the expenses that she usually is used to incur. It's a king's daughter. I say this because she's a fine lady. She is a very good tool. She will have prospects of development and growth. But AI coming in the houses of people, AI coming in the lives of people. So we have seen that students have started cheating on their projects using AI. We have seen that bank data is being fudged using AI. We have seen a very recent case where a deep fake of Honorable ex-Justice CJI Mr. Chandrachud was created, and the gentleman was fleeced for 7 or 8 crore rupees. A digital courtroom was created by AI,
Yes.
and the person couldn't make out. So these are some unseen dangers which have come inside your houses, in your pockets, through your devices, through AI. So we should really be very careful while seeking the hand of the king's daughter. We should be really careful asking whether we are really prepared as a country, and I feel we are not prepared as a country for AI yet. Maybe another 5 years, but not yet. I mean, Sandeep sir can throw a light because he's...
No, no, I'm not saying anything on the king or king's daughter, at least. so,
No,
so
I just
I
use
myself
this as a metaphor to compare with a fine technology.
I'm myself is afraid of kings and their daughters. So only point I wanted to supplement to what Shalendra said is, day before yesterday itself, the MITI has issued a report on AI governance guidelines development. So I think all your audience should go and read, and we should also go and read. That is one. Second is, AI is being used term so loosely in last 1 year in India. So even if, like, I would say that my broom in the house or my bed sheet is not AI. Otherwise, everything in the world is AI now. You go and buy shampoo, it will be mentioned that it's AI shampoo. Something like this kind of. So first of all, we should understand what is AI is one. Second, your question, coming back to your question, saying that how this law, this Digital Personal Data Protection Act of 2023, and the current scenario of AI use will coincide and will reconcile there. How do you manage that? So this law, the government is conscious of this fact, one. And this act itself provide, if I'll take example of social media, so whatever I put in my personal capacity, my personal sensitive data, or my pictures, or whatever information I put on social media for some blog, or just for a social media account, that is not covered under this law. All your audience should be aware. Say tomorrow I put a picture, somebody morphs that picture and uses it, this law will not cover me. You cannot go and say that I put some on WhatsApp or Facebook some picture and it has been taken there. So whatever you put on social media, it's not covered under that.
Yes.
This law will not protect. One. Second, I just wanted to supplement to what Shashank earlier said. So he said the primary duty and the obligation would be on data fiduciary, not the processor. The processor and then fiduciary's relationship would be governed by their contract, right? But there is a little bit of element and tweak in that statement proposition, which we should all understand. I'll from the act itself I'll read, and I think it will be better for the your audience. Say 2:1, Roman 1 says, data fiduciary means any person who alone or in conjunction with other persons, it could be data processor, determines the purpose and means of processing of personal data. So data fiduciary alone or in conjunction with other persons. So what other person could be? A data processor. So where the data processor takes the role of a data fiduciary, he decides what is to be done with the data. Then he becomes a data fiduciary itself. So the issue will come, say for example, breach has happened. Then obviously that data principal will go that I have given this data to this company or this fiduciary and it has breached. Data fiduciary will say that I have given this processing to the data processor. So breach has happened from his end. He has acted beyond what has been asked to do. So these kind of litigation, these kind of dispute will crop up. So this is a food for thought for all of us and for your audience. This should be things. So once the data processor deals with the data in capacity of a fiduciary, he becomes a fiduciary. He doesn't only remain the data processor. That I wanted to supplement. Second, one point he said, we are talking about a digital data. What about the other data? So the act provides itself data which is in digital form, or even if it is not in digital form, it has been converted to digital form. This act will apply. So if I've taken a picture of some information on some Aadhaar card, so Aadhaar card was in digital form. I got it. I took picture, I processed it. So it applies to all the data. So just clarification I wanted to put. Hope I have
So, yeah,
responded on
Sandeep,
AI
so
and yes, sir. Yeah, please.
sorry, quick thing. Sorry, I interrupted your chain of thoughts. Actually, so when you read that data fiduciary definition under DPDP, it's actually in line with what a joint controllership in GDPR will say. So, at any point of time, like let's say if if I am taking your data, I am your data fiduciary, and I, let's say, give it to Khyati for processing or storing. Khyati becomes the processor. Now, until and unless I tell you that Khyati will also do process this information for a certain purposes, till then Khyati is not a fiduciary. If you and Khyati jointly are deciding on how my data is to be processed, then only it will be kind of both will be a data fiduciaries. In that situation, the word processor is out of the place. So that is how, I mean, drawing parallels with what outside world is doing is what I was doing. So outrightly, in terms of the exact preposition, quote unquote, how we see in GDPR that there is an obligation on data processor plus obligation on data controller. We don't see it as is here. The rules and the draft says that fiduciary has to ensure that there are contractual safeguards, because it is, at the end of the day, it is their head on the plate.
Right. So what I was trying to say, see, we also have to understand this law in context of our country. So nobody wants to take bug on them. So what I'm trying to say is that dispute will arise primarily. See, why do we write contract? Not to solve things, just to complicate things. Just to have disputes. So on a lighter note, so data fiduciary will always pass on bugs on the processor. How successful they are or not they are, that's a separate issue. So this is the for lawyers I'm suggesting. So this kind of disputes you may have to address. This is just a thought. No quarrel on what you said. I'm in total agreement. I'm just giving my view to what the law is.
No, I mean, I just was clarifying where I was coming from. I'm not objecting to it anyway.
I completely bow down to that.
That was great. All the various prospects about it. Sandeep, sir, you have an experience of 20 years in the legal field. I wanted to ask you that what exactly does the provisions of alternative dispute resolutions, which are mentioned in Section 31 of the DPDP Act, could you please explain how mediation and conciliation could help restore data protection disputes instead of going through formal hearing processes?
Right. So I'll see. It's very basic and very thoughtful thing to put this provision in this act. And with this, see, ADR is could be barring criminal law. ADR could be a very good tool in any kind of dispute. So that is, I think, in the that it was in the contemplation of the lawmakers that there would be a good amount of dispute, and dispute, as the last example in our discussion we observed, there could be dispute between data fiduciary, data principals, and then data processors also. So there could be multiple parties involving it, and it could be a very techno legal kind of dispute because a lot of technology will be involved. And we should admit, as a lawyer and judges, we don't understand technology the way any technical person or person with some technical background will have. So to have, and when you go for this settlement or dispute resolution mechanism through mediation or some conciliation proceedings, so you all can engage and involve those experts and take their valuable input. Obviously courts will also have a benefit of taking input from those experts. But in this kind of law, and which is yet to be implemented, notified, having this provision will ease down a board on the existing mechanism, which will be the first court of instance data protection board and then appellate tribunal also, as we know that our courts are overburdened with already existing litigation. So I see it's a very prospective and good thought of legislators, and it will help ease down the burden on the board and the party stakeholders.
I agree, sir. With the growing complexity of data related disputes, mechanism like mediation could really ease the burden of the formal courts. So let's move on to Shashank, sir. Sir, one of the key discussions around the proposed rule is the balance between protecting individuals' privacy and encouraging innovation. Do you believe the rules successfully converge these two aspects, or are they leaning too heavily towards one?
Okay, so it's a great question. I mean, where do we balance? Okay, so when again I'll take you back to what West is doing on this one is whenever we do assessments, internal assessments, and it will tie it back to your current question. We always do a proportionality assessment whenever we are using it, apart from consent part, right? So whenever we are doing something for which is undefined, I mean, in GDPR, you'll see 5 or 6 legal bases of processing, which is consent, contractual duties, public health, public interest, vital interest, etc., etc. Now in India, you will see there is a consent and then there is other legitimate usage.
I think there is a network issue with sir.
Yeah, there was a freeze for about just 10 seconds, but I think we are back. Let's see.
I think freeze.
Shashank?
Shashank's screen is freezed, I think.
I'll
We all
connect.
are.
Till then, Shilendra sir, would you like to throw some light on this?
Yeah, I mean, so continuing from where Shashank took up, left. So the policy framework needs a lot of overhaul and participation from the private players. So what he was emphasizing on, I would have a little different view, although in line with what he was saying. The policies will have to be participated in. There should be public debates. Government should invite academicians, practitioners, as well as the red tape. So the executive of government, the organ of the government, it has to be a joint effort. It can't be a singular thing like we have drafted this law and now it's going to be a law. It is hardly a law which will work without public participation, without participation from academics, legal fraternity, even the judges. So it has to be a cumulative effort to make the policies work for the country. That's what I would add.
Shashank sir is back. I would like to speak.
Yes, sir. Please continue.
Sorry, my network is a bit shaky today. Okay, so yeah, I was at doing the tests for legitimate interest, right? So now, when you see the current structure of the rules, you will find that the biggest players, the significant data fiduciaries, as and when we also get clarification on which are entities they are going to be, they'll have to do audits. They'll have to do one thing that we call it as a DPIA, that is data protection impact assessment. So DPIAs, PIAs, and then you will also see the algorithms which are being used to take a decision. They'll also have to be assessed. We call them application assessments in our parlance, or a privacy by design assessment for a particular application. Similarly, AI assessments will also pick up because there is still happening. There is a framework out there in the open. So when you talk about balancing the rights versus the innovation, now, in my opinion, these set of rules with the vagueness that they have, they are allowing innovation to a certain extent. Now, in tech, there are certain do's and don'ts which industry has to follow. They should not leverage the production data, like the live data. They should ideally use all the synthetic data for testing and all these purposes. And things like that, the baseline requirements are set across industry. There are associations which are working on it. Versus now, when you go for the first time implementation, right now, I'll take it back to the time when, let's say, insolvency and bankruptcy code was put in place. Everyone was running left, right, and center, and how the bench was rolling at that point of time. And thanks to the bench back then, they were literate enough to rule on matters of IBC. But now here, the main cause of concern is going to be what is allowed or not. Because in the earlier version, there was a provision of sandboxing for SMEs. They were relaxed compliances were there. Now, certain few relaxed compliances are here in this version as well. Like the companies which are not SDFs, they may keep on operating with the temporary grievance officer, which was any which way has to be there under SPDI rules. So they can keep on continuing doing that. They do not have to have a full-time designated DPO. So, yes, there is an innovation that the obligations on different kind of entities are being divided equally as per the level of business they are doing, one, and the amount of data that they are processing too. So you will see the fines are also probably, as and when the things go to board or TDSAT or courts, probably the fines will also come in accordance with the violations, if there are any. And they have also ensured that, considering India is a very is a favorite country for litigation. Top countries where the matters are pending, they have tried to cut down on frivolous litigation matters by imposing fines also. Now guide so I was saying that it is also now on us as a lawyering fraternity to ensure that such frivolous litigations are also not sought, because again, it's going to
I think there's a slight network issue with Shashank sir.
I think he has conveyed his point by saying that there should be should be collective effort by all the stakeholders, including the government, judiciary, as well as for lawyers, because lawyers also need to advise their clients correctly before they initiate any action against the parties. So this is what I feel he was leading towards.
I want to thank you all for such a wonderful approach to that. How can both the things be balanced together? So Now, to wrap up with, I'd like to ask each one of you a common question. What advice would you give to law students or young professionals looking to specialize in data protection law? What skills or work experience do they require to stay ahead in this provision?
Right. So data protection officer previously were trained under the European laws, or they had certificate programming, program certificates with the uh, American uh, American institutions and national associations. Now, primarily, the requirement is that a person should be qualified as either a lawyer or in some branch related to data privacy. It could be cyber laws, or it could be just an IT professional who has an interest and who has worked in data protection. Now, the first important certification that we can look at is the CIPT, the Certified Information Privacy Technologies, which is conducted by the International Association of Privacy Professionals. Now, this is conducted by ANSI, National Accreditation Board of USA. And this certification is one of the toughest certifications on the face of the earth. If it requires extensive program-based learning, it also requires a lot of practice, and the expertise is applicable across the globe. Now, second is CIPP. CIPP is also offered by Association of Privacy Professionals. Now, there are different CIPPs. CIPP for Asia is different. CIPP for Europe is different. CIPP for United States. CIPP for Canada. So they are offering structured programs in your area of interest globally. Now, these are certificate courses that you can do. You can also go ahead and become a certified information privacy manager. There are various organizations across the globe which are offering it privately. They are also offering these certificate program courses remotely. But let's not make any mistake. Now, these are not degree programs. These are certificate programs which you can take up in addition to a law degree or a master's in law, or along with the IT engineering backgrounds. So these are few of the courses which you can go. I'm sure if IITs put their head, like something like IIT Kharagpur, which is also offering an LLB IPR, if it puts its head to it, IITs can come up with an integrated course which can offer a degree of data protection. I'm sure, but that's just a wishful thinking. Let's see how it goes.
Sandeep sir, what are your insights about it?
So I'll just so your question was primarily that who aspire to enter into this field of
Data
law
protection
as a
office,
lawyer.
yes.
So lawyers, I would suggest they should not confine their reading to law books only into today's technological world. They should read other subjects books also. So technology and then IT related books and journal books also. So that will help them to understand this technological aspect. Secondly, this all accreditation and certifications are designed by international organization for their indigenous laws. European GDPR, and then in US there are multiple privacy laws because it's a federal structure. So every state have their own law.
On laws,
So
yeah.
these certification could only help you so far as when you're dealing with the company or working with the company who are, dealing with the GDPR law, maybe in India or outside India. As of now, as on date, as we stand, there has been no certification approved by the government of India. That is one we should keep in mind before we enroll for any kind of international certification or courses. So be conscious of the fact this METI has a vision of vision, it's a division who deals with this kind of, giving accreditation or, certifying that these organizations are being given some power or authority to conduct these kind of courses. But at the same time, there are Indian organizations like FDPPI. So they are offering these kind of courses. If they wish, they can, take conscious decisions and do it. But none of them has been certified by the government of India. So in my understanding, they should, as of now, it will evolve. This law will evolve gradually. So they should start reading independently whatever available on the, libraries in books, and avoid the Google Gyan. So avoid just googling things and taking note of it. That's what I wish them, and best of luck.
Shashank sir, what are your advice? What you give advice to law students or young professional to specialize in data protection law?
So come be prepared. Law and tech, I mean, it's as different as what you read procedural law on books and how it is practiced in courts. And most of them, yes, it's good to be enthusiastic, but again, keeping a pace with the number of technologies and the updates to them on a day-to-day basis, right? How Microsoft is working today, within 1 hour, they might give you another update and you'll have to be up with it. What kind of security threats, how, and basically my advice is, before you come to practice anything, I mean, it's not just data privacy, learn about the core subject of it, the core industry of it. Because you cannot go and be a very good forensic lawyer or a criminal lawyer until and unless you don't know how things work.
Yeah.
So you cannot be a privacy lawyer until and unless you don't know how things on the back end are working. And that's something that I think all of us, I mean, as a generation, I mean, which is upcoming, and I see every day, there are new courses coming out left, right, center, and people are purchasing them. It's better to learn at your own pace. I mean, I understand Sandeep sir said that not to use Google Gyan, but yeah, for tech, probably go and learn tech. It's out there. I mean, you can get a lot of research available. You can do, you can learn coding, or you can see how databases look like. It will go as basic as that, how encrypted database looks like, or how a unencrypted database looks like. You can get those things out of Google to a bare minimum. Use GPTs, or use AI to your to build your understanding on what actually AI is. I mean, I missed out on what that AI question, but AI has been here for a while. All of us are using it. It is as basic as a chatbot on Zomato that you talk to every day for canceling your orders or getting a refund. Learn about it and probably come to this with an open mindset. Don't restrict yourself and your lawyer self from learning other things, because that's the biggest pro of being a lawyer, that we can do anything in this world, be it pharma, tech, banks, crimes, civil disputes, anything. But just you have to come with an open mind, come with a mind wherein you are open to learn a lot of things which were not taught to you in those 5 years or 3 years or 6 years of your law school. And then it's you're going to thrive then. If you're not doing that, if you're sticking to your okay, I am a lawyer, I'm going to do just the contracts and assessments and audits, not going to work. So yeah, that's my 2 cents.
I would like to thank you all the panelists for sharing such valuable insight. I was really grateful to be a part of this discussion and learn so much from you all. I would like to thank you on behalf of the Bar Council. I would like to express my gratitude to all the panelists, Shashank sir, Shailendra sir, and Sandeep sir, for their thoughtful contributions and presence on holiday to discuss these very vital data protection and privacy rules. Once again, thank you all for your time and contributions. Let's continue to engage and work together to learn, share, and grow. Have a great year ahead, sir. Thank you so much.
Thank you, Kathy, for being a wonderful host. Thank you,
Thank you,
Sandeep sir
Khyati.
and Shashank. Thank you so much.
Thank you,
has been a
sir.
pleasure knowing you.
Thank you, Kathy.
Thank you, everybody, and Happy New Year once again.
Ji, sir.
Thank you for the opportunity.